बोलिए।
साथियों, सभी को मेरा खत्यानी जोहार। देखिए, इस समय मैं सुप्रीम कोर्ट में हूँ और लगातार आप लोगों को अपडेट दे रहा हूँ कि क्या चल रहा है यहाँ पे वाकई में। और आज अभी कुछ देर पहले वकील लोग जैसे अंदर घुस रहे थे, तो ये मतलब कि देखिए, मेरा स्पेशली बात बताऊंगा तो मेरा टीजीटी के वकीलों से मुलाकात हो पाई है, बाकी पीएस के वकीलों से मुलाकात नहीं हो पाई। तो उनके तरफ से भी साफ साफ कहना था कि भाई आज सारे मैटर्स को एक एक करके सुनने का मौका दिया जाएगा और जितने भी यहाँ पे आए हुए हैं पार्टी बन करके, जितने भी लोग यहाँ पे आए लेकर के आए हुए हैं, जितने भी लोग यहाँ पहुंचे हुए हैं, सबको आज निस्तारित किया जाएगा, सबको निपटाया जाएगा। क्योंकि बीच में फिर हॉलीडेज पड़ेगा, इसी चीज को लेकर के जज ने सोचा कि नहीं, मेरे पास थोड़ा सा टाइम अभी कम है और इसलिए उन्होंने टाइम देने का प्रयास किया कि अब मैं 2 बजे बाद सबकी हियरिंग करूंगा, 2 बजे बाद सबके बारे में सुनूंगा और इसीलिए टाइम दिया गया है। तो उम्मीद करते हैं कि अब ये 2 बजे हम लोग के लिए बहुत अच्छा समय साबित होगा। तो देखिए, 2 तो बज चुका है। अब इस कोर्ट रूम में अब इसको आप लोग के सामने लाइव किया जाएगा। थोड़ी देर और आपको प्रतीक्षा करनी पड़ेगी। मैं आप लोग का चैटिंग भी देख रहा हूँ, मैं आप लोग का चैटिंग भी पढ़ रहा हूँ। मैं आप लोगों से आग्रह करूंगा कि आप लोग जरूर मुझे कुछ भी सवाल हो तो पूछें, ताकि मैं आप लोग को जवाब दे सकता हूँ। मेरी आवाज तो आप लोगों तक पहुंच रही है? चलिए, सभी को मेरा ऑल द बेस्ट और बेस्ट ऑफ लक कि सब बढ़िया हो, सब सही हो। और बहुत सारे आज बता रहे हैं कि बहुत यहाँ पे मजमा लगा हुआ है वकीलों का, बहुत सारे वकील आए हुए हैं, ठीक है ना, दोनों पक्षों के। और यहाँ पे सरकार के पक्ष से भी भले वकील है, लेकिन आज उन लोग के बारे में कुछ सुनने का शायद अवसर उनको ना मिले, ठीक है। और आज तो जैसे 2-3 चीजों को देखने के बाद क्लियर हो पा रहा है कि क्योंकि मेरा पंचायत समिति के वकीलों से मेरा कांटेक्ट नहीं हो पा रही यहाँ पे, और जिस कारण से मैं उनसे अपडेट नहीं ले पा रहा हूँ। लेकिन टीजीटी के वकीलों से कांटेक्ट हो पा रही है, पीआरटी के वकीलों से कांटेक्ट हो जा रही है, तो उन लोगों का ही अपडेट मेरे पास मिल पा रहा है, ठीक है। तो उन लोग किस तरह से बातों को रखेंगे। पीएस वाले जितने भी वकील हैं, चाहे अजीत सिन्हा सर हो, बाला सर हो, या तो फिर जो भी और कोई सर हो यहाँ पे, तो उनसे मेरा कांटेक्ट हो ही नहीं पा रहा है। और कांटेक्ट नहीं होने के कारण जो है मैं पंचायत सचिव के बारे में क्या आगे का मूवमेंट है उसके बारे में जानकारी मैं नहीं दे पा रहा हूँ। लेकिन बस धैर्य बना के रखें और थोड़ा और वेट करें, आएगा, जल्द ही आएगा। जितने भी लोग सुन रहे हैं सबसे मेरा आग्रह होगा कि बस धैर्य बना के रखें। सबका टीजीटी का और पीआरटी का स्थिति बहुत स्ट्रांग है सर, बहुत शानदार है। और अभी पीएस को लेकर के कुछ भी कहना मुश्किल थोड़ा सा, क्योंकि अभी उनके हमारे वकीलों से मेरी बातचीत नहीं हो पाई है, ठीक है, जिस कारण से मैं उससे कुछ भी नहीं बोल पाऊंगा, ठीक है। हालांकि सबको बोला गया है कि 5-5 मिनट कम से कम भी तो सबको सुनने का मौका दिया जाएगा, टाइम दिया जाएगा, ठीक है। तो उम्मीद है बिल्कुल आज टीजीटी एडवोकेट क्या बोल रहे हैं कि सब बोलेंगे, टीजीटी हो, पीएस हो, सबके वकील बोलेंगे, सबको समय दिया जाएगा। बस चूंकि टाइम तो हो गया, लेकिन थोड़ा सा और प्रतीक्षा करें यहाँ पे, क्योंकि डायरेक्ट मैटर जो है वो कोर्ट नंबर 13 पे लगेगा, ठीक है, सॉरी कोर्ट नंबर 5 में, और आइटम नंबर 13 पे ही लगेगा, और इसीलिए लेट हो रहा है थोड़ा सा। आशा करता हूँ कि आप लोग मेरी आवाज सुन रहे हैं, आप लोग मेरे भावनाओं को समझ रहे हैं कि मैं क्या कहना चाह रहा हूँ आप लोग को, ठीक है। जितने भी और साथी हैं, मेरा सबसे आग्रह होगा कि बिल्कुल भी पैनिक ना हो, सब बढ़िया होगा, अच्छा होगा, थोड़ा धैर्य बनाए रखें। और चलिए, कुछ अगर आप लोग के पास सवाल है तो मुझे जरूर बोलिएगा, ठीक है ना। हियरिंग स्टार्ट होने में थोड़ा सा 2-3 मिनट टाइम लग सकता है, रुकिए अभी। हियरिंग स्टार्ट होने में 2-3 मिनट का समय रहेगा, तो आप लोग देख ही सकते हैं, सब कुछ यहाँ सामने है। जैसे हियरिंग स्टार्ट होगा मैं आप लोग को बताने का प्रयास करूंगा, सब कुछ आप लोग को दिखा दूंगा, ठीक है। चलिए, बढ़िया है। और बिल्कुल, बहुत अच्छा। चलिए, सब टीजीटी के एडवोकेट के बारे में पूछ रहे हैं, मैं आपकी बातों को सुन रहा हूं और मैं कोशिश भी कर रहा हूं कि आपको जवाब दे पाऊं, ठीक है। क्योंकि लगातार आप लोग इतने लंबे समय से प्रतीक्षा कर रहे हैं, वेट कर रहे हैं, थोड़ा सा और समय वेट करना पड़ सकता है। बस कुछ ही मिनटों के बाद अब हियरिंग शुरू होगी, तो देखने वाली बात है कि अब क्या होता है हियरिंग में। बढ़िया है। जी जी बिल्कुल बिल्कुल, मैं सभी के कमेंट्स को पढ़ रहा हूँ। आपके कमेंट्स से ही मैं आप लोग को रिप्लाई करने का प्रयास कर रहा हूँ कि आप लोगों से मैं बात करते रहूँ, ठीक है। जो आप लोग मुझसे पूछना चाह रहे हैं मैं वो चीज आपको बताने का प्रयास भी कर रहा हूँ। यहाँ पे हो ही नहीं पाता है तो मैं आप लोगों को विजुअल दिखा देता हूँ वीडियो करके भी यहाँ पे, लेकिन क्या करूँ, कुछ कुछ प्रोटोकॉल होते हैं सुप्रीम कोर्ट का जहाँ पे आप अंदर में वीडियो वगैरह शूट नहीं कर सकते हो, ठीक है। डेट मिलने का तो कोई गुंजाइश नहीं है कि डेट मिलेगा, मुझे नहीं लग रहा कि डेट मिलेगा, लेकिन थोड़ा सा वेट तो करना ही पड़ेगा क्योंकि इतना दिन तक वेट किए हैं तो थोड़ा सा और वेट से ही मैं कोशिश करूंगा। फिर से पंचायत के स्टूडेंट ज्यादा एक्सपेक्टेशन के साथ यहाँ पे उतरे हुए हैं और उनकी मामला को भी काफी अच्छे तरीके से यहाँ पे रखा जाएगा आज। बिल्कुल क्रिस लिखते हैं कि जो भी फंडिंग लेना है आज ही ले ले, लेकिन आज ही क्लियर करने के लिए बोलिए। क्या डेट मिलेगा? कौन वकील डेट मांग रहा था? नहीं, जो डेट मांग रहा था आप लोग जैसे बात कर रहे थे, डेट मांग रहे थे सरकार की तरफ से जो वकील थे पल्लवी लांगर जी, वही डेट मांग रहे थे और इसलिए वो डेट मांग रहे थे क्योंकि जनवरी का डेट वो मांग रहे थे ताकि मतलब कि मामला खींचाए सिर्फ चुंबक के जैसा, रबड़ के जैसा, ठीक है। लेकिन यहाँ पे डेट मिला नहीं, अभी 2 बजे का टाइम दिया गया था तो इसी में सबको बुलाया गया तो बहुत सारे अब चीजें जो है स्पष्ट हो जाएंगी आपके सामने, ठीक है। एक बार फिर से ब्रॉडकास्ट को शुरू किया जा रहा है, देखिए वेट करिए थोड़ा सा।
In law, which I have succeeded in. Point one. You should know what it is not about, rather what it is about. There I'll come to in the end. So it is not about change in law. Number two, I'm sorry, my lord is then number two, it is not about compensation for change in law, which after torturous journey, I have succeeded in finally.
That you have already succeeded, no?
After a very torturous, agonizing journey, but yes, I have ultimately succeeded after a long, long time. Anyway, that I'll tell you. Number three, it is not about interest on that compensation which has to come on change in law. That is inbuilt. That also, Malus. Now, this is about LPS, late payment surcharge, namely. After your lordship directs that pay, the process of your lordship's directing and then contempt and then paying and then actual paying, it's taken an enormously long time. So I am entitled to one under a clause LPS. That also is not an issue. After a lot of months banging my head on this thing and requesting them, I have got that also. LPS, that is late payment. That's the whole thing I got. So why am I troubling your lordships? I am troubling your lordships because the issue is that admittedly they have to pay me, and I use the word admittedly, LPS at 9% SBR plus 2%. That is the state bank or the notified rate, whatever it is, it varies, plus 2%.
As per which clause?
Yes, versus them paying me at 9%. So they're paid, they accept they're paying, but they don't pay me at SBR. That's the short point of it. So your lordship will just see the points in respect of that. Your lordship's query, it is payable as per clause 8.3.5 at page 280 of the PPA.
8.3.5.
3.5, page 280.
Two?
280. May I read? In the event there is delay in payment of a monthly bill by the procurers beyond its due date, a LPS, late payment surcharge, shall be payable by such procurers to the seller, that is me, at the rate of 2% in excess of the applicable SBR per annum on the amount of outstanding payment, calculated on a day-to-day basis and compounded monthly rest for each day of delay. The late payment surcharge shall be claimed through the supplement. Now note just 3 dates or 4 dates. The Regulatory Commission order, which gave me change in law, is dated 17th May 2018. Let me just note the dates. I will not take a lot of time on that. But dates are important. The APTEL judgment in appeal affirming that, and one was giving me more relief because some amount of relief was not given, is 14.9.19. I am not giving also the pages because now it's not necessary. Then it came and was heavily contested in a Lordship's judgment in the Supreme Court, affirming my claim and affirming this judgment, is 31.8.2020.
Court judgment.
Your Lordship's court judgment. Now, review petition is dismissed of this judgment on 2/3/21. Each time 1 year passes, 1.5 years passes, etc.
You dismiss on?
On 2nd March 2021. Still they don't pay, which is fructified from beginning. So I file a contempt. The order directing payment of the lump sum, what the total, let's say, X plus Y plus Z, altogether 100 rupees. That is, fellows, your Lordship's judgment in contempt. It is 25 February 2022. So we have reached from 18 to 22. Despite that order, it is not done. And finally, your Lordship disposes of on 19/4/22. After it is done, the payment is made on 25/3/22 at 9% and not at SBR plus 2%. 2%, whatever the SBR rate, plus 2% above that. So, whereas the payment made at the wrong rate is made on 25/3/22, your Lordship may note that date.
According to the, what is the SBR?
Yes. The SBR rate has varied from 13, 14 to 15%, because the whole idea is that with respect to that rate, it varies. It is 13, 14, 15. And Malas, just turn to a chart, it will make it very simple. In my rejoinder of page 6, at one place your Lordship will get all the facts. Page 6, my rejoinder. So Lordship doesn't have to go into any inquiry.
Small.
Yeah, that is a very thin one. It's rejoinder,
13 page.
October 22.
13 page.
13 page. My Lord is right. Please turn to page 6. The Lordship does not have to go into details, just note 2 figures. Third column at page 6 is amount paid by them as late as 25 March 22. Does my Lord have it? Is 1478 odd crores. Amount required to be paid as per 8.3.5 is 2922 computed at SBI plus 2%. Difference is 1443. It is not disputed. None of this is disputed. The dispute I'll tell you in a minute what it is. It is not disputed that I paid you at 9%. It is not disputed that 8.3.5 says this. And it is not disputed that these are the figures. Now I'll tell you what the defense is. Just give it 2 minutes more. The defense is principally two things. One, that you go here and there, why are you coming here? Because I took care of that. I expressly kept this issue of LPS open when I was before my lord, because that time we were calling for the money. We were dying and again asking, please give us the money. You're not giving it for 4 years. So that issue was kept expressly open. In your lordship's order disposing of contempt on 19/4/22. I appeared, we said that we don't want to trouble lordship today, but please don't compromise my right to claim that. That your lordship's order is 19/4/22, disposing it of at page 232. Need not go there, but lordship will note first para. Already left the question open.
1 minute. 230.
232. This is the order of 19th April 2020. So please note, 8.3.5 is not denied. The rate being the difference
Sorry,
is not
which page? Which page?
well, at the top. 232, internal page 4, it says that. My lord has got that. As such since, does my lord have a sentencing? As such since.
Left the question of the late payment surcharge.
That's right. We are not inclined to pass any further orders. We already left the question of late payment surcharge open. Can claim for the appropriate forum. That's point one. Point two, Malas.
What is the appropriate forum?
Well, the appropriate forum is, it's a consequential order. Your lordship is passing contempt orders 3 times. Over 3, this matter started in 18. It landed up in the Supreme Court in 19. You have no business to pay me in 22. Just by ultimately you have to pay. But I have to knock on the door. Your lordship is to pass order after order. It's a consequential order, Willis. The clause matters. What matters is the clause. Is there a power? The quantification matters. Now the second argument is even more, Willis, curious and a little important. Your lordship's main order, your lordship remembers, is 31/8/2020, a date which my lord just noted. The principal order of my lords, performing all this payment to me, is 31 August 2020. My lord noted that in the list of dates I gave. Now, in para 67, now in that proceeding, there is no question of LPS. It had not arisen then. Your lordship were discussing carrying cost, which is interest, which is inbuilt into the clause, and compensation. I hope I am clear. Also change of no issue. But in a sentence, it appears that your lordship has used a word which did not arise. So they are saying this is now decided by that. Turn to that page. That is para 67.
At page.
That page. Which file? Main file 161. Relevant at 164, 165, but just turn to that. The main thing. Now this is actually a using, which is of a word, which is doesn't mean what it says. Your lordship is not dealing anywhere LPS. No LPS issue arose. This did para 64. No, 67. Well, it starts at 64. Just I want to show what the issue was, and then I'll come to 67. Come to 64 at page 164. Para 64 at 164. The argument raised by Mr. Sundaram that carrying cost is a penal. So the issue was carrying cost, which is interest. We are not concerned. All along the fight was over compensation and interest, carrying cost. We are not concerned with it today. But cannot be accepted with the decision in Uttar Bijli, Haryana, in which respect to carrying cost, it was held that carrying cost was payable in terms of restitution. Carrying cost, that is another fancy name for interest, basically, is to be paid on the same basis as provided for other dues. Now let us come to 67. At page 167. So, lordship may take it. The entire judgment is on compensation and carrying cost on compensation. Nothing to do with LP. Lordship may take my word for it and checked up fully. Now just see what happens at the end of 67, which is being misused by the other side, according to my humble submission. Last 6 lines that my lord will see in para 67. In our opinion, it would be appropriate to direct the appellant's Rajasthan discount.
Which page?
Well, I'm sorry, 167 is the page, 67 is the para number.
Sorry, it starts with regard to the...
With regard to the question. So please see that. With regard to the question of interest late payment surcharge. Now what has happened is, they put an oblique. Interest is carrying cost, late payment surcharge is something totally different. But they put an oblique. So now see, Malas, the last operative portion of 67. They were not considering the issue. The issue didn't arise because the application, the request is made afterwards. Kindly bear with me for a minute. When will I ask for late payment surcharge? With great respect, let us kindly consider. After the amount has become fructified, the amount became fructified only on 31st August 2020. Your Lordship's judgment for the first time came on 31st August 2020. So I could not ask for late payment surcharge. Now see the last 5 lines of para 67. Yeah, just read the, it will become clear if I read the last part of 67. Can I read 67?
1 minute.
Part of 67. Two things. Mr. Sundaram's argument that time was that we are concerned with the interest till the date your Lordship finalizes on 31A. No question of LPS arises, it will arise later. See that at page 119.
No, only difficulty, Mr. Counsel.
That is LPS used, the word is used.
No, not that. Para 66 may be read.
Yes.
We will read para 66.
Yes. Liability of late payments. I'm reading after the quotation, or should I read from
Para 66, considering the facts of this
the
case.
facts and keeping in view that RC and FTL have given concurrent findings with regard to which we concur. We may now deal with the question of liability of appellants with regard to late payment surcharge. In this regard, the following articles which are relevant are extracted below. That is expected. Liability of LPS, which has been saddled upon the appellants, is at 2% in excess of applicable SPR on the amount of outstanding pay, calculated on a day-to-day basis and compounded monthly rest for each day. Therefore, there shall be a huge liability of payment of LPS upon Rajasthan discounts.
Then read further.
With regards to the question of increased late payment surcharge, notice the plea of change of law initially raised by APRL. The case was also filed by APRL itself. However, the appellant Rajasthan discount did not allow the claim regarding change in law, because of which APR was deprived of raising the bills with effect to the date of change in law. We are thus of the opinion that considering the totality of the facts of this case, in order to do complete justice and to reduce the liability of appellants, payment of 2% in excess of applicable would be on the higher side. In our opinion, it would be appropriate to direct Rajasthan discount to pay interest as per applicable so and so, which should not exceed 9%. Now mark the word, pay interest oblique LPS. Just mark that line.
No, it was after considering 3.5 counsel.
I appreciate
And considering taking into note that it will be a huge liability upon them.
Yes.
Thereafter, consider that so far as the late payment charge is concerned, it may be 2% in excess of SBAR, but it should not exceed 9%. That is the problem.
Absolutely correct, Manoj. That's the problem. May I explain why, Manoj? It may not be a problem. I understand my loss very completely. The issue arising here till the end was only carrying cost. Carrying cost is a fancy word in electricity law for interest. Interest in that, because what they've done is they have taken LPS to be interest. Let me explain this. Change in law is 100 rupees. On that interest, till the time of the change in law, is 10 rupees. So 110. That becomes an invoice of 110. Now, if you pay 110 rupees to me after 10 years delay, then you'll pay a late payment surcharge on the late payment. Now, they were considering only 110 rupees, not the late payment. Just see that at page 119. They were not even, what they've done was the oblique is a problem. They are saying interest.
Not oblique, Mr. No. Oblique is not the only problem.
They've-
The discussion in para 66 is the problem.
Well, they have quoted.
And specifically stated that late payment charges 2% plus SBAR, correct? But in the fraction circumstances, to avoid any huge liability, it should not exceed 9%.
Because capital used
68
is the standard used. There is no clause for carrying cost. There is no clause for this.
It is made when?
Let me this
1 minute, will be right.
the actual payment is 25th March 22.
25th,
March 22. The confusion has arisen
As per
because they have taken.
9%, we've already paid.
sorry?
As per 9%,
No, that-
That's not the issue.
25th
No,
of
Mr.
March.
Counsel, Mr. Counsel.
Yes.
The point is assuming, correct, for the time being, you may be right. Correct? 66, 67, 68, considering 8.3.5 everything. But the liability accrued, correct, in 2020, it came to an end.
That's the point.
Correct. This got directed you to make the payment at 9%. Correct. Immediately on 31/8/2020, you were required to make the payment. You cannot continue to pay the interest at the 9% annum. Correct. For the period even subsequent to 31/8/2020. See the difficulty.
But the difficulty is
1 minute. 1 minute.
today, not
No. You may be right, mister, that so far as still this got passed an order, 31/8/2020, your liability to pay the interest at 9%, we may for the time being accept it. But what about the interest, the late payment charges after 31/8/2020, when the rights of the parties were crystallized finally?
page 65. Para 65. Para 65 crore.
Like post technical interest, which is LPS, they took 9%.
We may not say late payment charge from the day one, but at least you have to pay the late payment charge from 31/8/2020.
Para 65, page 165 is what I would say I would read for your lordship. Now what I'm saying today, lordship, there are 3 judges, honorable judges of this court, including your lordships, who are a part of that bench. Today, my lord,
No, we accept, try to appreciate.
only one vote. Only one vote.
But thereafter the division bench, thereafter 2-judge bench in contempt proceedings, correct, has kept,
5 orders plus.
correct, has specifically kept the open with respect to that
That's
late
like-
payment charge open.
That's like every day your
We have to strike the balance between the two.
But that's like what your lordship is every day we're not doing. When your lordship is dismissing, not while dismissing we ask for a relief and the lordship says, okay, liberty granted if we not advise so.
Okay.
That's precisely what has been done here.
Okay.
So you know today say
Anyway, but
he gave a right.
okay, you tell us, correct? Why should we deny that late payment charges, correct? As per 8.3 from the period 8/3/2020,
No,
31/8/2020.
31 August.
two
You tell us.
reasons I give. Not one, it should go back to the 3 judges.
No, it should not go because of the fact that
Secondly-
earlier the contempt was also by 2-judge bench.
4, 5 orders.
Secondly-
You did not take a objection at that time also.
We said.
No.
Our
On that day,
objection, our
but the
objection,
contempt order is passed by 2-judge
our
bench.
objection was there to the effect.
In the Supreme Court, there is nothing like 3-judge or 2-judge. That is for convenience, everything is. Virtually, unless the matter is referred. You concentrate on merits, mister, rather than on technical whatever.
No, it's not technical. With utmost respect.
Okay, we will consider it. What do you say on 31/8/2020 when the rights were finally crystallized and your liability to pay the interest along with 9% accrued? Assuming that late payment charge was 9% till that this court took a decision. But what about for the period after 31/8/2020?
Page, para 65, page 165.
Please read. Please read.
It was argued that the RERC and the APTEL had not determined the amount. It is apparent that the principle has been worked out by the RERC as well as APTEL. Quantification directions have been issued to Rajasthan Discoms to verify the documents, because our case was that they have not submitted those documents. Our case was they have to give documents of the coal procured, of the energy produced.
That was everything over, Mister.
No, not
Change in law, everything was over.
It was not. It was not. With utmost respect, my lord, it was not. Let me read further, my lord. Quantification directions have been issued to Rajasthan Discom to verify the documents submitted by APRL and make payment in terms of the judgment and order. Nothing further was required to be done by the RERC as well as APTEL. So the lordship goes on to say that it takes into consideration the late payment surcharge, it takes into consideration the interest. I mean, we filed a review.
You are right, Mister.
Your
But that
lordship
is,
displays the review.
Mr. Counsel, that is up to 31/8/2020. But what about after 31/8/2020?
I'll just find out. Yes. So if your lordship will see, during the contempt jurisdiction, when they say that this money is due, but we said based on our computation that we have done on the documents so given, 506 crore odd rupees was due from them, which is why your lordship said that if such a situation so arises, then please, this is not the forum, go to the appropriate forum. So our claims are also pending. We have not come before the court.
No,
Saying that under the
your,
contempt
whatever
jurisdiction,
your claim is concerned in approval process, it will be dealt with
that's the
counsel.
direction for them also, my lord. Kindly have the order, my lord. Once again, the contempt order.
Let us see.
Yes. One second. In the prayer of the ME. Have page 232, which one senior colleague.
Yes, we are having counsel. I am having counsel.
Yes, my lord. As such,
Read the entire thing.
yes, my lord. At page 232 only, my lord, that will suffice if your lordship wants, I'll read the whole thing.
Read from page 22, 229 onwards. In compliance of this court order.
Sum of rupees 5,996.44 crores has been paid by the respondent discoms to the petitioner, which according to the respondents is towards the full and final payment in compliance with the court's judgment dated 31st of August 20. Dr. Singhvi's counsel for the petitioner submitted that out of total sum paid of so and so crores is towards the principal amount, 1,469 crores is towards carrying cost, interest, 9% per annum, and the balance amount is so and so is towards the late payment surcharge. So late payment surcharge, as per your lordship 31st August, your lordship had said it will not exceed.
9%.
It will not exceed.
At the rate of 9%.
And your lordship specifically deal with that 2%.
Okay, Mister. We take it.
It is true. It is thus contended that there is no full compliance of the judgment of 31st August 2020 of this
No.
court.
One read this. According to the petitioner,
Yes.
the late payment surcharge ought to have been rupees 2477.00.
As per 2% surcharge,
And there is a substantial shortfall of over rupees
1,300 crores. It is thus contended that there is no full compliance of the judgment dated 31st of August 2020 of this court. The senior counsel has further submitted that the said payment is made, it is only up to November 2021. After the said period from December 21 onwards, the respondent has not paid any amount towards the principal or interest. Lastly, it is contended that in an affidavit filed by the managing director of RUVN, the respondent Rajasthan Utilities contends that it would be entitled to certain claims outside the judgment dated 31st of August. So they say outside, for which it seeks leave of this court to claim from the petitioner, which is vehemently opposed by Dr. Singhvi, learned senior counsel, as according to him, as per judgment of this court, dated so and so, quietus has been put to the litigation between the parties. Per contra, Mr. Sundar, learned senior counsel for the respondent, has submitted that on payment of so and so, full compliance of the judgment dated 31st August has been made. It is contended that in the said payment there is no component of late payment surcharge. What has been paid is the principal amount of 54,745 crores minus 2,426, which has already been paid, rupees 3,048 crores plus 9% interest compound annually till March 2022, which comes to so and so crores, totaling of rupees 5,996. It is thus submitted that after the payment of interest, that's 9%, there is no question of late payment surcharge. As such, the issue raised by the counsel for the petitioner is not worthy of acceptance. As regards the second issue, which is, this is, I can skip, this is our requirements, and then kindly have page 232 now. Can I read?
One minute.
Can I read 232?
Yes.
Your Lordship may read it to me.
Yes, Commissioner.
That's the division bench. As such, since according to the respondents, the payment made is only towards the principal amount plus 9% interest per annum, we are not inclined to pass any further orders as we have already left the question of late payment surcharge open, which the petitioner, if so advised, can claim before the appropriate forum. And your Lordship can decide which is the appropriate forum. If it is so, let it go back to the three judges or the bench, or let them go back to the actor.
No, which is we are considering from the,
or the RER.
The order passed by two judge bench council.
Yes, my lord. Yes, Lord.
And see, admittedly, the amount due was paid pursuant to the order of 25 to 2022.
MA is filed in the MA is in the civil appeal now. It's not in the contempt.
Correct.
It's not in the contempt.
Correct.
So, because it's there, my lord, it should ideally go back to three judges.
If the contempt can be heard by two judge bench, why the MA, Mr.? Try to appreciate. Otherwise, the same thing it will be done. It is not a review.
Let me read further. What our contention was. And why the court thought it fit to go.
No, we are not on that, Mr. You may be right. You are not liable to pay any late surcharge. Correct? Up to 31/8/2020, you may be right at the rate of 2% plus the SPR. Correct? Till 31/8/2020, we may not settle with the liability because that has come to an end. Either you listen to us or listen to him.
I'm listening to your lordship.
Otherwise, it's a very difficult counsel.
I'm sorry, your lordship.
Because
One sentence, sir.
1 minute.
Sorry.
So we are, because admittedly the amount of this amount was paid pursuant to order dated 25 to 2022, though the order was passed on 31/8/2020.
Yes.
Correct?
Yes.
Which you were required to pay immediately on conclusion of the proceedings on 31/8/2020. So the question is only at present we are considering, not liability which has come to an end pursuant to the order of 31/8/2020.
I'll answer that. I get what your lordship is saying. Let me just.
Now you satisfy us why, correct? The late payment charge from 31/8/2020 till the actual payment was made, correct? We are on partial relief, not the full relief which they are asking.
I quite.
In fact, they are asking for the entire late payment charge, which we may not grant because of the observations made in paragraph 65, 66 and 67.
Yes, Lord. But for putting forth my point, Lord, may I just read a little further? As regards the second question of the alleged compliance by the respondent after November 2021 of the judgment and order dated 31st of August 2020, we would not like to make any observation as there is neither any material before us with regard to that nor the same was in question when the contempt petitions were filed. As such, we leave the question open to be agitated by the petitioner if so advised. And go further, my lords. With regard to the last issue raised by the respondents, that is us. We also said that 506 crores is due to us. Direct the appellant Rajasthan Discom to make a late payment surcharge of 1,376 crores outstanding as on 30th of June 2022 to the applicant in terms, and how that figure was not reached at my colleague was not, he read that out. So they are asking for the entire.
That is what we are pointing
Yeah.
out, Mr. Council. We may not grant that relief at this stage, correct? But at least from 31/8/2020, we are saying,
I would say.
and your rights to recover the amount of whatever due and those are kept open, Mr.
But what I'm saying is, it should not be piecemeal. Your Lordship may not.
No, but contempt court has already said.
Contempt court has said, Lord, whatever is before us, we have decided.
Correct.
And rest of things are open to them to go and claim before the appropriate.
No. With
So
respect
the
to,
paragraph that I read just now.
no. That is what we are saying. This is with respect to your claim.
No, my claim is the third last paragraph.
That is what we are
As
saying.
far as the petitioner is concerned, it's paragraph 2.
Correct.
As regards the second question of non-compliance of the after November 2021.
But we are, Mr. Council, try to appreciate. We are not considering the entire relief from the date from 31/8/2020 2010. We are only considering from 31/8/2020.
I would say, Lord, an exercise should be done by the appropriate forum in toto.
What appropriate?
Because my claim today, we
This is-
say them. Today, your Lordship.
No, there cannot be appropriate forum for the period after 31/8/2020.
Because it's continuing. The bills were not submitted. Kindly have again page 165, para 65.
Council, you paid the amount of on 25 to
They
2022.
accepted without protest. They accepted.
No.
it as it is.
Not. They said that it was not. Otherwise, this observation would not have been there.
Kindly have para 65 again and 66. Read it in conjunction with.
Correct.
I'm sorry for being.
No difficulty.
And what I want to show is basically, my lord, 8.3.5.
Yes, Council.
It was argued that the RERC Aptel had not determined the amount.
You are also succeeding. They are also succeeding.
But when we are holding.
LP, late payment charge, you are succeeding for 10, I think not 10 years, more than 10. 2010 till 2020.
No, we paid.
See, what substantial amount you are getting?
We have paid, my lord, in all 8,423 crores.
Yeah, correct. That is
Which
pursuant the order passed by the APTEL.
3,000 crores
Confirm.
is the interest.
Yeah, that is bound to be there as per the contract and as per the order passed by the.
The pointers being given, my lord, to today to reopen, re-agitate by way of an MA,
That you are right, Council.
by way of a content.
Anyway, we are again and again we have not to tell you, Mister. You are right. Correct. Up to 31/8/2020, correct. There is a quietus. No dispute about it. No doubt it can be said to be. Only thing is after 31/8/2020.
8.3.5, if not to be
Yes.
again at page 165.
No,
It shall be thereafter.
correct.
In the event of delay in payment of a monthly bill by the procurer. So the question is of those monthly bills, the submission has to be there. If the submission is not there, what do we verify? What do we check?
That was not even your case before the.
That was, my lord. That's what para 65 and other paragraphs say.
These I know, Mr. Distinctly recollect. Even I was not in favor of the 9% also. Correct. But ultimately, because it was.
Your Lordship read?
Yes. Yeah.
And now Lordship has come to page 166.
Page 166.
Yes. Why your Lordship did not? Not give surcharge.
No.
Liability of late payment surcharge.
We have not refused. We have said it is restricted to 9%.
That's what I'm saying. So in a way, your Lordship.
No.
What your Lordship is saying is
We
right.
consider 8.3.5. It will be a used liability.
Excess.
Correct. And therefore, considering that used liability, it is said that from the date on which the contract that till the appropriate decision is taken, it will be 9%. That late payment charge.
Whatever, but your Lordship and your wisdom.
We
is not-
restricted it to the 9%.
Yes.
But till 31/8/2020.
Well, I would say appropriate forum, your lordship may decide.
No, no.
Let all of us go.
Which or you tell us which appropriate forum?
I also have a 506 crore rupee claim.
That, why have you initiated any proceedings?
No,
for that?
because it was before appropriate forum as per
You initiate the proceedings, Mr.
No, we will go to RERC. They will not. They will get it from here. Will not. Who's going to give
No,
it?
no. So far as we do not know what are your dues.
I just said so. Contempt court takes it into consideration.
Okay.
Can I just read that again? But very categorically it says.
Correct. Last paragraph. No?
Yes, last paragraph.
Correct. We have noted. Therefore, you initiate appropriate proceedings for recovery of that amount.
So it should not.
At present, we are concerned with the LPC.
It should not be piecemeal. Lord is what my
No,
supposition.
that is already.
Or in the alternative, Lord, if your lordship so thinks, if your lordship is expanding, Lord, then your lordship may give me an opportunity to come place it before this court.
For what?
For my claims of 506 crore rupees.
But that how can we say? It's quite division bench order.
It's not different. It's a calculation of accounts on the basis of the payments made, my lord.
Mr. Try to appreciate. So far as that is concerned, in view of the last paragraph, we cannot say anything. We cannot do anything.
But same should apply for them also.
No, that is also.
Just because they come in MA in a disposed of my lord petition,
Is okay.
which has retained finality
So
from
we will consider.
August.
Now you tell us what will be the interest, Mr. What will the LPC according to you? We also may not saddle with the liability.
It has to be continuing. It will be 9% only.
You have paid this 9% interest up to 31/8/2020 or till the payment is paid.
Till the payment.
2020.
March.
Ah.
March 23rd of March 22.
From the beginning till March.
That's why I said, 3,000 crores, 2,900 odd crores.
3,000 or 300 or 3 crores makes then no difference to us.
Because the fact is that we have paid, we have complied. And complied till 23rd of March 22.
That is what exactly, Mr. we are telling.
Yes.
Ah.
We prepared a note, my lord, which will just one single page note will, my lord, help your lordship also to get the figures.
ये पंखा पड़ेगा। No, we will, Mr. Counsel, you may be right. We will not keep the question with respect to LPC, correct, prior to 31 and 2020, because even division bench judgment contempt, correct, it is also kept open. Even
With the direction appropriate for
correct,
them. The
why
lordship
should-
will decide
but
upon
we
it.
have, but we have the parties ultimately. Why should we leave it to open to the for that period also for 20 years? You will be. Why should that question be kept open?
This amount will increase.
I to appreciate. We are telling in your favor, Counsel.
I quite see.
We are telling in your interest.
It is in the larger interest of the
That is what
public
exactly
also.
we are trying to tell
The
you.
larger interest of the public also. Not 31st August is the not judgment. Thereafter, my lord,
We just want to restrict it from 31/8/2020 till the actual payment is made in 2022.
At the rate of SBR.
my respectful submission is
Otherwise, if
we have paid on
you can
23rd.
we keep the matter after some time. Also, you apply the mind properly, correct, and tell them what is in their interest, correct. Otherwise, what will happen as per the division bench or the contempt court order, correct? Everything will be at large, correct, from 2010 onwards, Mister. See, it will not be in the larger public interest. We will have the fighters and we will pass a final order, correct, that no liability prior to no LPC prior to the 31/8/2020.
Let me take instructions and come.
Correct, only on that point we consider that.
Sir, I
3
don't
minutes.
want to say anything without a proper instruction.
No.
My lord,
That is what we are telling you.
3 minutes. Just come to 121. I heard your lordship loud and clear. I know what your lordship has said. My learned friend has said something. Just come to 121. I'll take 3 or 4 minutes. LPS was not there. I'll tell you why 8.3.5 was used. That my lord is rightly saying. Just see, Mr. Sundaram who appeared for them, his contention at 121. Just give me a minute.
Mister, then it will be very.
No,
in your para 65 to 68, Mister.
I'll tell you why it happened. Give me just three. I should have said so earlier. Well, let me raise this point now, so I'm saying it. Just give me 3 or 4 minutes. I'll not take long. This case was about carrying cost. What happened was, my claim is, give me carrying cost at SBR. I should have said so sentence first. I thought it was obvious by nothing to say. My claim was, give me SBR for carrying cost also. Now there's no clause for carrying cost. So your lordships used 8.3.5 to apply that rate for carrying cost. And while applying it, your lordship said, however, to apply for carrying cost, where there is no clause, SBR plus 2% will be very high, so I apply ad hoc 9.
Not with respect to carrying cost.
Yes, just see this. 121. Give me 2 minutes. Just 2 minutes. 121. That's what is important.
Very difficult.
Mr. Sundaram says this.
65 to 68, very difficult.
I'm just pointing out, I will leave it to my lord. Your lordship.
Still we are considering from
Saying from
31 2020.
30th August onwards, that is what is the period. I'll spend close crores at your lordships. That is 2013 onwards.
I don't know at lordship.
No, it's
We
figures.
paid you.
See this figures is given here, but does he tell a lordship of 2013?
Okay, 120.
He has not paid. 2013 is the date. You are also saying 2010 is 2013 onwards. So
2010 is the agreement.
today, Balas, if he doesn't pay this late payment, this quietest word your lordship used, whose interest is it? He's a discom, he passes it on to consumer. This period, this meter will keep ticking. It's better to put a quietest in his own interest, as the lordship says. Otherwise,
that is what he will get an instruction.
now just turn to 121. Just 2 minutes I will take on these 2 points. Your lordship may not have seen this because I didn't show it to you.
No, if this observation would not have been there, correct? In para 65 to
I understand.
68, correct?
I'm explaining it by saying
We would have kept everything open.
that's right. So your lordship is not hiving off at least 2 to 3 years and making it from 30th August. I hear my lord loud and clear. I am saying that this 9% figure came for carrying cost because I asked for SBR for carrying cost. Your lordship said we will take the analogy of 8.3.5
No,
and limit.
that will be reviewed.
Because there is no clause of CC. Now just see, Mr. Sundaram himself said, this case is not about LPS. Just turn to 121. This case is about carrying cost only. That's the problem.
It is only specifically with respect to
Kindly see
late
Mr.
payment charge.
Kindly see Mr. Sundaram at 121. This is their case.
Correct. Dispute was with you.
Unless the 2 periods are separate, there is no logic to apply the late payment surcharge, which is for the second period. Apply what? I said.
Correct.
Apply 8.3.5 to carrying cost for which there is no clause. Your lordship said not that, but 9%. Mr. Sundaram says don't apply it at all because LPS doesn't arise here. So, Manus, what has happened is actually happened.
Mr. Dr. Singh, one please. Please read 66 again. Very difficult, Mr.
Manus, 66.
66 specifically with respect to the late payment charge and
Yes,
surcharge.
late payment surcharge because I said.
Not it is that applicability of the carrying cost with respect to late payment
I'll
surcharge.
tell you why. It is for the clause because there is no clause for carrying cost. So I utilized SBR to apply to carrying cost. Now see one more thing.
But it will be reviewing the order.
Well, anyway, I cannot say more than that. Your lordship has suggested, according to me, a highly beneficial Y media to them. But Baras, I am not agreeing.
And we wanted to strike the balance between the two.
The matter, Baras, otherwise the meter runs against them onwards. Suppose Baras they don't.
That is what we
pay
have
the balance.
conveyed.
Then your lordship directs them to pay the balance after 10 years. Who's going to bear this 10 years cost?
That is what he will take the instruction.
Now, there's one more.
You advise them properly.
There is a judgment of your lordship.
What is in their interest, what is in the larger public interest, Mr. Otherwise, if it is kept open from 2013 onwards, correct? And we do not know what will happen. No, you also don't know what will happen.
Absolutely, bro.
It will go to some forum. It will be decided after 10 years. He'll pay that thing after 10 years.
Correct, that is what exactly we are impressing upon them.
Just
We'll come back.
just you should know this. Your lordship decided in 2022 for SCC 657 that the contractual rate of SBR for electricity matter 2022 for SCC 657 paras 195 to 198. They're very evocative paras. That SBR is not high, is not arbitrary, and contractual.
No, we are not on 8.3.5. Whatever was the 2% plus SPR, correct, from 31/8/2020 onwards till the actual payment was made.
I would say that.
And that to be,
What my learned friend is saying, this present judgment on para 202, specially stands distinguished by the subsequent judgment that is being referred to, and that judgment is to judge.
we are not on that.
That's on the SBR rate.
Yes.
You can impress upon them.
I will make it.
My learned friend can see instruction, otherwise we've been mentioning this a lot. You can see in
Or
the.
we'll pass on.
No, I thought
Subject to hearing you. For 10 minutes we are hearing
we
you.
have it
I think tomorrow.
on the reopening.
That your lordship.
Third in part. Third in part.
Yes, possible lordships can give the letter.
Having got the verdict on respective parties at length, we are prima facie of the opinion that applicant shall be entitled to the late payment charge as per clause 8.5.3 at least from
8.3.5.
8.3.5 at least from 31/8/2020 till the actual payment was made pursuant to the order passed by this court in contempt proceedings. If that is considered, we have the opinion that it will be in the larger public, it may be in the larger public interest and the original appellant that Jaipur Vidyut Vitran Nigam Limited may avoid further litigation with respect to late payment charge from 2013 onwards till 31/8/2020 over and above the 9% already paid pursuant to the earlier judgment and order passed by this court in the main civil appeal. So lauded ASG Jain ne?
Yeah, Jayan sir.
Jain Sood. Lauded ASG pays for some time to get the further instruction. Full fine. Put upon which date?
Any date on reopening.
They asked the
And
earliest.
your lordship has fixed the date. No,
So we had difficulty that we've got your lordship a heavy crowded board today hearing.
Yeah, we have to hear Mr. Diwan and
Tomorrow.
Jharkhand.
No, no, I know lordships can take it up tomorrow, day after. I can only make a request.
Day after tomorrow bench is not. And
In January, the earliest date.
I'm not aware.
Whatever the earliest date you know.
नॉन सिटिंग बोल दिए हाँ बता दे देख लेता हूँ नॉन सिटिंग कभी नॉन सिटिंग लेट पेमेंट सरचार्ज
So give me the earliest available your lordship's calendar in January. What can I?
January 10 to CBA.
10th is the constitution.
The CB.
CT. The lordship is part of this.
The 6 January.
6 January. Right.
6 January कौन से?
Could be after.
January.
I'll leave it to lordship.
6 January.
You get them. Let us see if we'll consider it.
Very deeply obliged.
Yes. Jharkhand.
This is a one-page note ready.
I have to give us,
Let it be one at a time.
yes,
I'll leave it.
we'll go one after the other.
Well, it is by whom we do not know.
That's my lord.
That's-
पल्लव सिसोदिया नाम लिखा है
I have also written the IA numbers and the name also.
पर आपका नाम नहीं लिखा योर नेम
Can we also get copies of
अमृत होम नाम लिखा है
If you give us copies only, then only we can respond.
One minute.
ये short note is by whom another third one is for by whom नवनीति प्रसाद अजीत कुमार सिंह This is by whom? Suggestions to this honorable.
by myself on
ठीक है।
behalf of this person.
हम लिख के देने
तो बोलूं the status of the applicant check is who has given?
Yes, madam. I will. Yes, sir.
Now
They are beginning.
who are on one side and who are on other side?
We don't know which side we are on. What will start with a note because Lord, there are three issues now.
Petition is filed by me, Milord. If I may be, Milord, allowed to, Milord, open.
Now you are satisfied?
So, Milord, I have three things to point out, Milord, and then Milord, I will just. So, a compliance report has been filed yesterday night,
Compliance report लाए.
which is the affidavit dated 13/12/2022.
13.
13/12/2022,
Sometimes you see,
which is yesterday.
to show some grace and to save the appointment, this is the problem. If everything would have set aside, then no difficulty.
Please. This is the affidavit filed late last night, Milord, is what I understand.
This is by Pallavi.
Yes. So it is found by one Mr. Ravi Kumar, secretary, and it runs into 4 pages of affidavit and then annexures. So may I? The total number of pages in this is 37. It runs into 37 pages.
Yes.
Milord, I want to first place, Milord, two things, Milord. Your Lordship will kindly come to paragraph 4. Further, the order dated 2/12/2022 passed by this Honorable Court also directed the state government to prepare a list of original writ petitioners who had approached the High Court and may be appointed, adjusted in the concerned scheduled and non-scheduled district. Accordingly, a status report was filed by the state government on 8/12/2022, which is what your Lordship was seeing earlier, what your Lordship had in your Lordship's hand. Inter alia, placing on record details of original writ petitioners before the High Court from amongst the list received from the contempt petitioner herein. Simultaneously, the Jharkhand Staff Selection Commission has issued a list of 245 original writ petitioners as per their merit list for verification of their documents. The Jharkhand Staff Selection Commission is likely to take a period of 1 month for the document verification and recommendation in respect of these 245 candidates who were the original writ petitioners. Thereafter, the state government would require a period of 1 month for completing the formalities related to their appointment. Therefore, the entire process for appointment of these 245 original writ petitioners shall be completed in a time period of 2 months. Apart from the above, para 5 number, apart from the above 245 original writ petitioners, the state government has identified the names of 143 writ petitioners who have filed the writ petition before the impugned judgment in the Soni Kumari versus State of Jharkhand was rendered by the Honorable High Court of Jharkhand at Ranchi, and therefore these writ petitions were disposed of relying on this Honorable Court judgment by orders dated 30/8/22, 31/8/22. The Lordship judgment is of 2nd August 22 and 17/11. It is submitted that the state government will take steps to complete the process of verification of candidates as per the orders of this Honorable Court on 2/12/22. Copy of the list is enclosed herewith. Now, my Lord, 3 things I want to wish to bring to Lordship notice, my Lord, with your Lordship's leave. If your Lordship take the contempt petition, and if your Lordship will kindly come to page number 123 in your Lordship's order, in your Lordship's judgment rather, but I am so sorry. The High Court passed an order on the bench of the Chief Justice after the reference had been.
हेलो।
उठ कैसे गया?
अरे लाइट चला गया है, मोबाइल से लाभ आ रहे हैं, आपका भी नेटवर्क चला गया था ना, कर रहे हैं, करवा रहे जनरेट। 2 मिनट रुक जाइए।
Which are marked there.
Sorry, madam. I don't have the paper name. Again, of the what we have been handed over, kindly see that. This is an order of 7 January 20.
What is your submission?
No, I am only pointing out that these number of writ petitions were not taken up with the full bench. Thereafter, my lord, another order judgment was passed on 30/8/2022 by the Honorable High Court. After your Lordship's judgment here on 31st August, my lord, which is at page number 12, and your Lordship will come straight away to page 28. Page 12, at page, my lord, 28 meaning 30, sorry, page 30,
Page 29.
page
30.
31. 3031 is the order, my lord, passed on, my lord, 31/8/2022. After your Lordship judgment, allowing all these writ petitions. Writ petitions were prior in point of time pending disposal of full bench, and therefore, my lord, these matters were also disposed of. So I am only wanting to bring to your Lordship's notice this, that I had identified those petitions, writ petitioners who were with me, 216. The other, my lord, the compliance report shows in para 5 that they have identified 143 more writ petitioners. So those are because of these orders.
Correct, we got your point.
Yes, that's what. And so far as I am concerned, my lord, compliance has been done. So far, because we are put in the name of this first paragraph 4, para 4, our names are all there, 216 which we have given, and their matters have been sent for verification.
At present,
So far as my report is concerned.
216 plus 100 for the further
Yes.
13% cases are under consideration by them.
245.
I've just handed over the same sheet again. I've just handed over the same sheet again. Great. May I just state my point? And I'll just go through the note, but let me just state my point. I was before the High Court as a respondent, intervener, pursuant to what Mr. Ranjit Kumar just placed. There were an advertisement and public notice. I pleaded myself, so I was before the High Court. I was happy with the impugned judgment because it did not affect me the judgment which was impugned in this court, the full bench judgment, because I had applied in a post for a non-scheduled district. So I'm in the non-scheduled district category, and being non-scheduled, it was not the subject matter of the full bench decision at all. It came up here, your Lordship's final judgment. I was absolutely satisfied with that, no grievance or concern with that at all. My problem began with that 2nd December order which was passed by this court. And I'll just come to that in a moment. So can I just now run through my 7 points and then I'll just take you to the 2nd December order. Applicant interveners had applied for a post of non-scheduled district areas. Each of the applicants, pursuant to an advertisement and public notice issued in view of the directions by the Honorable Jharkhand High Court, impleaded themselves as party respondents to the proceedings, which culminated in the full bench judgment. Intervener number 1 was impleaded at number 2362. Intervener number 2 was 583, and intervener number 3 as respondent 31 before the High Court. The applicants have no grievance whatsoever to the judgment of the full bench of the Honorable High Court. The full bench in its judgment in para 63 at page 80 of my IA notes that the appointments made in non-scheduled districts were not challenged in the writ petitions. Further, in para 66, the full bench clarified that the selection process in the non-scheduled areas were never stayed. Additionally, the applicants have no grievance
with the judgment of this Honorable Court dated 2nd August 2022, affirming the judgment of the full bench. Applicants are affected by the order of 2nd December 2022 of this Honorable Court as interpreted by the state of Jharkhand. Since the applicants are high on the
Let us see that order.
Yes, now that your lordship will find, if your lordship, if the courtmaster can hand over my IA 19052, you will find that order at page 191. It may also be in the content.
We want ready, Mr.
Your lordship has that IA, you will find that that order of 2nd of December begins at page 189. The relevant portion is at page 191.
Please read.
Your lordships have it?
Yes.
Yes. So should I just place this order before the court?
Yes.
I'll just place it and then go back to my note. Let the state prepare a merit list of those candidates who are actually appointed both in the scheduled area and non-scheduled area. Thereafter, whoever a candidate in the non-scheduled area is found to be more meritorious than the last candidate in the scheduled area of which he has given option, then that candidate in the non-scheduled area be adjusted in the concerned scheduled area as per his merits, and the last candidate in that scheduled area have to be reshuffled and adjusted in another district among those who are already appointed. Similarly, with respect to those original writ petitioners who approached the High Court, their merit list also be prepared by the state government, and they may accordingly be appointed and or adjusted in the concerned non-scheduled or scheduled district as per the merits. However, it is specifically observed that except those who did not approach the High Court, the benefit of this order shall not be given to them. List on 9th of December 2022. Now I'll just go back to my note and then I'll just make my short submissions. So I said in para 4 that the applicants are affected by the 2nd December 2022 order. Since the appellants are high on the merit list of the non-scheduled areas, they expected to receive appointment letters amongst the 17,784 posts advertised. Relying on the order of 2nd December 2022 passed by this Honorable Court, Jharkhand is considering appointments to only, now this is my first problem, to only original writ petitioners before the High Court. Despite the present applicants being party respondents / interveners before the High Court, they are excluded from the scope of consideration. So this is going to be one issue. Para 7. Further, the order dated 2nd December 2022 of this Honorable Court, referring to the appointments already made, the state of Jharkhand is excluding the present applicants from consideration. The state did not issue appointment letters to the applicant, even though there was no embargo on making appointments for non-scheduled areas. And now, on the basis of their own inaction, they are attempting to exclude the candidates who are not actually appointed. Now, may I just indicate what has happened? Since I was applying for a non-scheduled area, I was not directly concerned with either the full bench judgment or your lordship's judgment, because there the focus was very clear. Now, in that backdrop, I was not affected adversely. However, I was before the court, I had implemented myself as a party respondent. Now, after your lordship affirmed the judgment and passed those operative...
Why you were not appointed?
Yes, now, very important. What the state of Jharkhand did or considered was, even though there was an interim order and even though the High Court full bench notes there is no embargo whatsoever, they stayed their hands. They did not make any appointment in the non-scheduled areas for all these years. So they granted an injunction to themselves. So therefore, all these 17,000 and odd posts remained vacant, and now they are seeking to make an appointment pursuant to your lordship's final judgment, over which I have no problem. But now the problem, now I'm just articulating my issue because of the 2nd December order. The first concept in the second line is, were actually appointed. Now, I was not actually appointed because there were no appointments made in the non-scheduled areas at all. So, all of us who had applied for non-scheduled, who are not concerned with this controversy, are finding this observation limiting. So, I'll make a suggestion also. So, this is the first point. Let the state prepare a merit list of those candidates who are actually appointed. I would consider your lordships to add the words or appropriate phraseology, or entitled to be appointed. So either appointed or entitled to be appointed. I am entitled to be appointed because I am very high on the merit list for the non-scheduled areas. This is one problem, one issue, sorry. Then please see the last part of that same sentence, that same paragraph. You have to be reshuffled and adjusted to another district among those who are already appointed. I am again suggesting over there also, please use the expression already appointed or entitled to be appointed, because then I will not have this problem at all because it covers thousands of us across the state who never receive, who are not even the subject matter of the main petition. Now, please see the next
No,
paragraph.
Mr. Shah,
Yes, I'm sorry.
The only difficulty, so far as this is concerned,
Yes.
we may consider the case, correct, with respect to those who were not appointed for not part of them.
Yes, yes. Yes.
We may consider.
That's right.
But to reshuffle everything, correct?
No, but there's no shuffling.
We,
Yes, I understand. There were no appointments made in the non-scheduled areas.
Your case can, subject to asking them.
Yes.
Your case can be considered,
Right.
correct? Or not, because your case was a non-scheduled area.
Right, and very higher. I mean, that's what I claim.
They did not make the account because of the pending litigation.
Yeah, for the scheduled area.
Correct. We have, in the main judgment also, we have noted that
Yes,
aspect
yes,
also.
yes. Agreed.
That at one point of by distinct recollect, it was observed that there was no order with respect
Para
to no.
66 of the full bench also notes that.
It is specifically
Correct,
mentioned.
correct.
We'll ask them
Yes.
that why the appointments were not made.
Correct.
If you are entitled to correct, but it may not be.
Yes.
Correct. You can be appointed.
Yes.
Subject to hearing other side.
Of course.
If the post have remained vacant.
Yes.
Correct.
So today,
Then
yeah,
on the vacant post.
Yes.
In the non-scheduled area.
Yes.
Subject to this, your case can be considered for appointment.
yes, I'm very grateful.
But not that because to appoint you,
Right.
somebody already appointed, correct, is to be.
No, so now may I just one small point which I'm
Yeah,
making on this aspect.
you be satisfied with the appointments.
Yes, I agree. So your lordships, when you put a question to the state, please also ask them, out of the 17,000 seats which I have mentioned, how many were 17,784? How many were vacant on the date of your lordship's judgment? That will provide a benchmark, because I am told even to this day there are 9,000 which are vacant.
We'll consider.
Now the second issue is on the next paragraph. So I'll just make a suggestion. Similarly, with respect to the original writ petitioners who approached the High Court. Now your lordship recalls we were all impleaded as respondents. So we were before the High Court.
No, this is with respect to, this is with respect to those,
Yes.
correct, who were already appointed, correct, or they were not appointed in scheduled area because of the bar.
Right.
So, these observations are with respect to them. These observations are not with respect to those, correct, who applied in the non-scheduled area.
Absolutely right. Absolutely right. But what is the state doing? Because now they filed a compliance report. They are not interpreting it in that manner. That is exactly how we understood it.
We consider it.
Yes. So I'll just come. So that last part also, which your lordship is clear. This paragraph is really with regard to the scheduled areas. That's second. And similarly, I think the third paragraph of the order also goes with the earlier paragraph. However, it is specifically observed that except those who did not approach the High Court, the benefit of this order shall not be given to them. I am only suggesting I was before the High Court as an impleaded respondent. So for all, obviously the High Court didn't want 10,000 writ petitions.
All are selling.
Yes.
I
This
want to
is
just,
very grateful. This is my point.
Lord, I want to just complete, Lord,
Don't raise the voice.
Just
Lord, may I just supplement
Like
what,
what will be heard subsequently.
Lord, may I just supplement what Mr.
Yeah,
Deepak?
we have said from this.
Lord, but let us, Lord, I may kindly take
1 minute. Arre, we-
after,
fine.
Lord, only 30 seconds.
Which one only did? Yes.
Lord, 30 seconds.
No counsel.
Your Lordship, may I have my note, 2-page note. Now,
1 minute. 1 minute.
Lordship will see the notes on the right-hand top.
Arre, but we are, let us first of all.
It is in contempt petition 707, item number 13.1, right-hand top, Your Lordship sees. Or on the page 3, my name is there.
No. Pallab Sisodia.
Saroj Kumar Mato, the name on top.
Sir. Yes.
Now, the petitioners before Your Lordships have filed this contempt
I
action.
wrote, not read it.
Your Lordship.
You see the.
The petitioners are for scheduled area. They had been selected and empaneled their document verification was going on for appointment. Now, some of them were appointed, some of them were waiting their document verification when the writ petitions were filed. The process of appointment carried on till a stay was granted by the High Court. And that is how some of us got appointed, some of us, even after document verification was...
You got the appointment in schedule area.
Your Lordship, we were empaneled for appointment in scheduled area.
Correct.
Are
And
we-
so far as those persons who were appointed in scheduled area,
Your Lordship.
their services were as such required to be terminated.
Your
But
Lordship.
we protected the services of those who were already appointed.
Your Lordship.
Ah.
Now
So
what-
the question was only with respect to non-scheduled area and the scheduled area.
Your Lordship.
Correct. Those who applied, correct, for scheduled area, correct, but they were not considered because of the notification and the bar under there. So that is the only point which is required.
Now,
So your case stands on a different footing, Mister.
Your Lordship, the state is taking the plea that as we were not the writ petitioners, we were not required to file a writ because we had been selected.
Then you file your independent proceedings, Mister. We are not concerned with that.
We were already selected. It was
That
not...
was counsel. That was not the controversy before the court.
We were not selected. We were selected. Therefore, we
But-
were not to file a writ petition.
Correct, but then you initiate the proceedings. We were entitled to. Sorry, we will not consider your case.
We were paid respondents in the writ petition.
Okay.
And all the
We
entire...
protected the service. We protect the service of only those persons who were appointed in scheduled area. Correct. So that they may not have to go home.
Your Lordship, we were in the merit list.
Maybe, Mister, but you were not appointed at all, no?
We were selected. We were in the select list already.
You were not appointed, no, in the scheduled areas.
Your Lordship, our appointment process was on.
We will not say anything so far. We will not clarify anything so far as those persons are.
What they are doing is they are not even considering us now. When your Lordships have
When
directed,
you file appropriate proceedings independent before the High Court, that will be
Your
concerned. We do not.
the persons who are being considered are below us in the merit. They are
Okay.
being considered.
Then you point out to the High Court that the persons who are having less marks than me are appointed, so please appoint me.
No,
Correct.
the Lordships have said that they will take up people on the last from the cutoff. Now we are way above the cutoff.
Okay, we are not on that. We are vis-a-vis those persons who are to be transferred to the scheduled area. We are not going to expand the scope of the writ petition at all.
No, Your Lordship, in these in 8 districts of scheduled area, no appointments have been done at all.
Okay.
Now, as per the merit list, all we are saying is consider the merit list. We can't be ousted.
We cannot reopen everything.
Your Lordship, because the merit list is already with them, they had made the merit list. Now they can't exclude the meritorious people and take people.
You initiate appropriate proceedings. We are not restraining you, counsel.
They are taking your Lordship's observation that as you are not the writ petitioner and as you have got no relief from the court,
No,
you will not be
We
considered.
will not reopen. We will not expand the scope of that. Just wait.
May please, my note. My note is also there, my lord. I am similarly placed to that of, in fact, one step further, is that after the High Court judgment was passed and your Lordship rightly noticed the para 66, I am the toppers, I am representing few toppers in the non-scheduled area, my lord, for the subject of Sanskrit, my lord. Their process was also completed, my lord. Selection was
Okay, then you are the same with
the same. Only thing is, I also made an application before your Lordships, just one second. I also made an application before this honorable court, your Lordship may recall, not to consider this while passing the judgment in that. Your Lordships were considering only the scheduled districts, so I was requesting that time also my appointment may be made. Process was complete, not, but they never made, they put their hands tight,
Okay.
only because the court was this.
Yes, please, sir.
I'm only praying that.
Lordship, I kindly take my note.
So, okay, then we will not hear all, Mister. Yes,
Lordship, I kindly take my note.
we consider you.
Lordship, I kindly take my note.
Yes, sir, we are ready.
Now, Lord, first paragraph I have pointed out.
Who are you?
Lord, I am the interveners
Who are you?
who are also before the High Court and not before your Lordship.
Who are you? We
Lord,
know, Mister.
Not
What was your status?
Lord, we were not given employment, though not here in the state merit list and the
You
district
applied.
merit
You applied in the non-scheduled area,
non-scheduled area.
like Miss Mona.
Like Mr. Diwali.
Huh?
Like Mr. Diwali.
Okay,
So-
1, 2, 3.
Yes. Now, Lord, there are three.
Okay, we will consider it.
No, now, Lord, three scenarios which emerge. Lord, I'll just read three sentences from my note. Kindly see, Lord, first part of note, I have given the background of the stay order, the misinterpretation, etc.
Now, not the first. Lordship may come to bottom of my first note. One straightforward option is to complete the recruitment process on the basis of state-wise merit list. This ought to be done irrespective of who goes out or comes in, except on merit. That's suggestion one. Second is not, the Lordship turns the page. Another option is to protect the incumbents already in employment. Though it was expressly negative in the final judgment of this court at PG Swens, even after accommodating those already in employment, more than half the vacancies shall remain, for which selection process on the basis of state-wise merit must
No,
be
we do
resumed.
not follow that. The incumbents already in employment means
Not the appointments which were already made, your Lordship said that they would not be disturbed.
correct. We have already stated.
Fair enough.
Our order is very clear.
Yes, so Lord, out of 17,784, even half the vacancies are not filled.
We are
That process was going on.
Correct.
So for
But
that,
it was only with respect to non-scheduled area.
yes, now Lord, both, everybody, throughout the state. Because now, as per your Lordship's judgment, there has to be a state-wise merit. Now, state-wise merit may mean that some people who are already in employment, but they are lower in merit may go out. Now, if that option is out, then the other option is that keeping them also, still not more than half the vacancies are to be filled.
That we are
So
considering.
yes. Now, the third is important, Lord. By the order of 212 is misinterpreted now to confine selection process to only the original writ petition before High Court. This gives a fresh employment to about 388%, as Mr. Kumar has pointed out. Majority of whom are not in merit, either in the district-wise merit or the state-wise merit. This compounds injustice to candidates much higher in merit who had no occasion to approach the High Court and are otherwise content with the main judgment of this honorable. That assuming the original writ petitions are to be given employment regardless of merit, more than half the vacancies shall still remain, for which selection process on the basis of state-wise merit must be resumed. Now, Lord, the clients, the persons whom Mr. Kumar represents, even on the new merit, which is state-wise merit, they don't come. Only decibel is the merit in their favor.
And they have succeeded before the High Court. In fact,
Fair enough, Lord. I don't.
they approached the High Court.
Lord,
They
I don't-
succeeded.
I
And
don't-
they will not get the benefit beyond
Please,
the
Lord.
ground that they were not meritorious, Mr.
Very well, Lord.
You never, all of you never approached the High Court.
Lord, we have no occasion. Lord, we are in merit either way, Lord.
Your appointments were not made.
Fair enough, Lord.
Anyway, we will
So-
take care of Mr.
So, Lord, so even if 388 are accommodated, even then, Lord, more than half the vacancies.
And don't repeat counsel.
Let me just point out one more fact. After your Lordship's order of 2nd December, Lord, the process which was going on, we all got a one-line order that अपरिवार्य कारणों से appointment process रोका जाता है. That should be resumed because that would not take. I am also in the secretariat.
May I start with this second one? Now, I appear for people whose advertisement of was 2017, not the subject matter. The post were LDC, Panchayat Secretary, stenographers and others. Total post advertised was
Not part of this advertisement.
My learned friend will again interrupt. That's the problem. We never interrupted. Let me say in a motion, Milos, otherwise I'll lose my control. I'm not confident like him. Anyway, 4950 is the total
You
seat.
will lose your control or confidence.
I'm losing both. The flow comes.
We are worried about losing the control.
Then it will be very difficult.
Very difficult.
I know that. So now I am maintaining my control and cool and addressing the honorable court.
Don't interrupt Mr. Kumar.
I'm so grateful. Now, 4950 was the seats advertised in 2017. That is not the subject matter.
What is the
The posts are stenographer, LDC, and Panchayat Secretary. My lords have recorded the argument in civil appeal number 4043 in paragraph 2. 4043, my lords have recorded the argument. State has moved an application supporting us. That is item number 5. I must take it. I will not harp more than that. That permit me to declare the result. Everything was over. Not a single has been appointed. So there is no dispute on that. That is my humble submission. State MA is 38161 of 22.
MA number?
एक second, yeah. 38161 of 22.
Sorry, 38,
I'm sorry, 38161 of 22.
38161.
Yes, my lords,
Of-
of 22 by the state of Jharkhand. And para 8, if my lords may just permit me to take that copy, because that will have a bearing on our matters, and I'll keep quiet after that. I have moved also an application, but the state supported us.
What is your IA?
Milos, my IA is, I'll just give that number, Milos, 36802 of 22. And the item is 13.3 in today's board, Milos.
Okay, we'll consider.
Milos, just one paragraph I'll show and state.
Read it.
May I? That is, Milos may make a note of it. State application, page 8, para E, and prayer number, yes, she is there, she is also saying that. May I pass on the copies? Copy. This has nothing to do with that, and not a single post has been filled, 4,000, and there are only 3,880.
Okay.
Milos may come to,
Others may not have any objection with respect to others. They are concerned with the teacher.
they are concerned with teachers. Me and Bala are
So we clarify.
yes, only to that. And now the
so-
switch has moved, just permit me to read the prayer and then I'll sit down.
Why are you coming? We have not passed any order on LDC. Why are you
That
coming?
is why they have sought permission, Milos.
Of what permission?
But my lords have dealt with it in para 2 and not passed the direction. That is what they say. If I may read Milos para E at page 8, that will clarify. The same thing which I said, Milos, it is recorded in their,
Yes, para E.
Milos, at the top para E. Running page 8, Milos. That para 20 of the judgment, my lords, got it?
Yes.
This Honorable Court refers to Civil Appeal number 4043 of 22 and relates to advertisement number of 1 of and 2 of 2017. The said advertisement was floated for appointment on the post of Lower Division Clerk, Panchayat Secretary, District Level Post, Lower Division Clerk, State Stenographer, State Level. However, there is no reference to this civil appeal in the operative part of the judgment. Then next page, Milos, they have prayed for issuing direction so that they can advance.
Why don't you file the application in 4043?
Milos, that's my appeal.
That is
Because in the High Court, if my lords may recall,
That is what we are saying. If there was no, then you should have filed an application in 4043.
we filed it.
Ah.
We have filed it.
Your IA is in 4043?
Yes.
Okay.
I'm sorry, Milos, I was not clear. That is 13.3 listed today. Same prayer which the state has sought, we are also seeking the same prayer as diary number 368.
But their application is in 4039.
No, Milos. In fact, if my lords may see the prayer, other clarification including mine, for teachers also. If my lords may see, page 8 I was showing, Milos. At the top, Civil Appeal number 403, para E. My lords got it? Running page 8 of State Affidavit. At the top. Civil Appeal number 4043 of 2022.
See?
My lords got it? Running page 8, para E of the state application.
correct.
At the top, Milos. In para 20, Civil Appeal number 4043, in
Correct.
which I have also moved.
Correct.
And then the prayer is at next page, Roman 5, page 10. That it should be extended to advertisement number 1 and 2 of 2017 at the bottom, Milos, on page 10.
Para 5.
I'm grateful. Roman 5. The ratio of the advertisement number so and so may be extended to advertisement. That is their prayer. Only thing what happened, they wanted that tomorrow I may not be, let us seek a permission. Same prayer we have made it in our application also, and not a single C, and the entire dispute is of teachers. Mine is already ready, Milos, and even the documents have been verified. They had to declare, they have prepared the list, they have to declare.
But what about the scheduled area and non-scheduled area?
Milos, that is what they have to give the final list based on merits.
They have to consider, no?
That is what
They cannot restrict the scheduled area of candidate only.
They are not restricting. Para 8. Para E itself says, they clarify that it is in bottom line, Milos. Para E, last 4 lines.
Yes.
Accordingly, Milos, if my lords may see.
Yes.
Accordingly, the preparation of a state-wise, the same thing, category-wise, service-wise, merit list followed by allocation of district in the district cadre through counseling in order of merit may be applied also in advertisement, that is our advertisement. So same thing, they are praying for it. So,
But not that it should be restricted only to the candidates
No.
in the scheduled area only.
they have not even one has been appointed. 4,000 seats are available, 3,000 something. They know that. I am relying upon the state and they are seeking permission to implement it. I am so grateful. Deeply
My lords, my application is similar. I am
Similar.
sailing with Mr. Ajit Sinha, my lords.
So am I.
My MA is 38389 of 2020.
1 minute. What is your number?
Yes, MA 38389
2020.
of 2022
Okay, we'll consider.
in civil appeal 4043.
We'll consider.
Yes, my lord. Same.
19684.
Your is one, MA number 38389.
Yes, my lord. Yes.
Then 1.
Yes, my lords. And the application is only in relation to this advertisement 2017,
that
which
I
is
know.
actually, my lord, the same
Okay.
advertisement.
Mr. Das, what is your number?
My number is 196841.
Sorry, 1
196841
of
of 2022.
IA or MA?
It's an IA in the main matter itself. In petition. We'll hand over notes also to the.
What name? Any other belonging to that
Deeply
particular?
obliged for the entire.
Any other with respect to the 2007?
No. We only 3 of
One, let us one by one pass an order.
Please, ma'am.
We are left. Two of us left.
We are concerned with those, at present the LDC and others, not teachers.
Yeah, correct.
Let one be over.
Right.
Okay. MA number 38161 of 2022 with IA number 36802 of 2022 in CA number 4043 of 2022 with MA number 38389 of 2022 with IA number 196841 of 2022.
41 and 46. 41 and 46.
41 and 46. 196846. These applications are with respect to the appointment on the post of 1. Lower divisional clerks into bracket collected cadre bracket complete dash district level post, 2. Panchayat secretary dash district level post, 3. Lower divisional clerks dash state level post, 4. State stenographer dash state level post for which the advertisement number 1 and 2 of 2017 were issued. Full point. The litigations in the earlier, the dispute in the other matters was with respect to the appointment in the teachers, appointment of teachers in the scheduled and non-scheduled area. Full point. So, the ratio, what is the main number? So, the decision of this court.
Civil appeal number
No, in the main, the teachers matter, 4039.
4050.
4044 is the main judgment which was rendered in Satyajit Kumar versus
4044.
4044 and another connected appeals. Very many connected appeals.
But the lead order was 4038.
Milos,
4038.
4038 of 20.
and connected.
So the decision of this court in civil appeal number 4038 of
2022 and connected appeals was with respect to the teachers. It is verified that the said ratio shall be applicable with respect to the appointments for the posts in question, namely so and so, 1, 2, 3, 4. And therefore it is clarified that the state has to prepare the state-wise, category-wise, service-wise merit list followed by allocation of districts for post in the district cadre through counseling in order of merit for the post advertised by the advertised number 1 and 2 of 2017, and the process of appointment be made in accordance with law on his own merits. Full point. However, the bar, earlier bar, with respect to the scheduled area candidates only, shall not be applied. Full point. With this, the therefore there shall not be any impediment in proceeding further with the recruitment appointment pursuant to the aforesaid advertisements.
1 and 2 of 2000.
Aforesaid advertisement.
Right.
With this, present applications stand disposed of.
A lot of repetition and contempt petitions are filed in high courts.
All
They should not come here to you, your lordship, saying you have not heard us. No, I'm just informing the honorable court that you are only few people.
Our shoulders are very.
My lord can just protect the state, saying all the repetition, contempt petition pending in the high court are disposed.
No, we cannot.
Only one thing, Milos, I have given 2 months time, Milos. They have also prayed for 2 months time. Within a period of 2 months.
Yes, and yes, sir.
So the repetition may be given coitus manner.
Okay, now you can't pass it.
I'm in non-city area, my lord. My lord, just one minute. My name is in the list, my lord.
Non-scheduled area we consider.
Yes, my lord. My name is in the list, my lord. My lord,
Your lordship, 1 minute.
on 3/11/2000.
We have heard you, counsel.
Your lordship, I just
No repetition.
not repeating, your lordship, I'm just pointing.
We have already, so far as those persons who are not appointed in scheduled area, we will not pass. It will be open for you, correct?
Document verification was to be done, my lord.
Are we are not on you, counsel.
Your lordship,
And then Mr. Vikas Singh said that we are losing the. He doesn't understand what is our procedure.
your lordship, what I have.
He is saying in the open for his own purpose.
Your lordship, the thing is,
Consider our difficulty also, Mr.
Lord, I said so, Lord, your lordship, for forgetting, I said so, that we see your lordship sometimes getting impatient, but we don't make up for this.
your lordship, what.
And Mr. Sibal in the morning only said that your lordships are keen, even though your lordship may hear only one at a time.
I am the tiger.
Your lordship, the only verification we had sought was that those who had already been selected, they can't be ignored.
Go and file a writ petition before the High Court and your cases on merits will be considered, counsel. We will not say anything.
Because after your lordship sought.
What is your IA? You tell us IA. What is your IA number?
Your lordship, we have filed the contempt, your lordship, 707. Your lordship, because after your lordship passes an order, the High Court is not going to modify that.
No.
All we have.
Your contempt is 707.
Your lordship.
Huh?
Now once we
These
have.
are the persons. We are dismissing your contempt. Sorry, counsel. Contempt number 707 of 2022. So far as the petitioners are concerned, they are the persons who as such were never appointed in the scheduled areas.
We were in the select list already.
Though according to the petitioner, they were in the select list. Full point. This is the contempt petition. Full point. The dispute was with respect to the
Hello.
claim between the candidates belonging to the non-scheduled area and the scheduled area. Full point. We see no reason to entertain the present contempt petition. Full point. However, it is observed. Hence, present contempt petition stand dismissed. However, it is observed that if the petitioners are having any claiming the right independently, they may approach the High Court and their claim writ petitions be considered in accordance with law and on their own merits. With this, present contempt petitions stand dismissed.
Your lordship may
That's
say
one
smooth
less
law.
counsel.
Your lordship may say
My
smooth law.
number,
Dismiss oblique disposal.
my IA number is 191417. This is by Praveen Bharti.
Who are you?
Not we are in the scheduled area.
Hmm?
we are in the scheduled area. Selected candidate, my lord.
Like Mr. Damriti Prasad.
Yeah, my lord. Yes, probably like him. Now, my lord,
What is your IA number? What is your IA number?
IA number is 191417, but I want to say something. I 191417 of 2022. Now, my lord, the direction which was given by your lordships on 2nd of August 2022 said that we'll prepare a merit list both for scheduled and non-scheduled.
Sir, council, that was only for the purpose of adjusting those persons who were the non-scheduled area to accord in the scheduled area.
My lord, we were not agreed by that. Now, subsequently, when the order was passed by your lordships on 2/12, what your lordship said that if you are not filed a petition before the High Court, then it will not be considered. Now, what I have said is, my lord, because we were all...
That is an interim order, council. We are still considering the final order. Correct? We'll vacate that. I'll vacate that 212 order.
Only that particular portion will
That
not...
is vacated, but then the state is in any case considering it. That is my side.
My difficulty is this. There was no occasion for me to file any petition before the High Court. I was selected. Now, because of this particular observation which has come, that if you are not before the High Court, that
We will pass the same order which is passed in Mr. Navneet. You can initiate appropriate proceedings.
My lord, I am asking myself a question. Main judgment, I am covered.
Main judgment, you are not covered.
My lord, I am...
That was not the controversy with respect to your non-appointment at all.
Questions directed in para 28, I have quoted, just kindly have a look at that para. I have quoted in May, just read, my lord, the para.
We don't want to expand the scope of our original appeal.
Lord, it falls within the directions which are given by lordships in the main judgment. In the contempt, my lord, because the lordship said if your petition is not, I am affected. Now in contempt, my lord, because of those observations, if I am covered by the main judgment, my lord, the relief should come to me. Now what your lordship said...
Sorry, council, we will...
My lord, I just want
IA
to...
number 1914.
I want to read, my lord, that para.
Read it, council. You are wasting all of your friends' time. You have no difficulty. We are here up to 4 o'clock. We are reserving the liberty in your favor to approach the appropriate court.
Just to only point out one thing, my lord, your lordship directed, it will apply merit list to both scheduled and non-scheduled. That's all. If your lordships, my lord, are aware of this particular direction, scheduled and non-scheduled, not only to scheduled, it says both. The merit list will be combined for both. That's your lordship directed.
Okay, we'll
I was not agreed by that.
Okay, we'll consider.
I am also, Lord, mine IA is Lord 193303.
Your lordships, my only
330
193303.
19330 3 of 2022.
2022. I have my only problem is 2nd December. If your lordship vacates 2nd December, Lord, the state is in any case.
You are in the scheduled area or
I am
non-scheduled
in
area?
the scheduled area, but I am in a subject which is history, which was in a separate controversy in the High Court. So no appointment had happened. So we are all within the merit list. We will make it in the entire state also.
We'll consider it.
So we don't need to go to the High Court again, Lord. If your lordship just vacates 2nd December, the state is in
We'll consider it.
Yes, our facts, just one second, Lord. Our facts are a little different.
You are
Just one diary number for a similar order. Diary number 40962 of 2020.
I don't need to be relegated to the High Court. That's all that I'm saying.
That is
Because
circulated in the office.
your lordship's main judgment
That is
covers.
already circulated in the office now.
ये डायरी नंबर ने वो उसका डिस्पोज किया ना उसके साथ में करिए कंटेम्प्ट में हाँ फर्स्ट 447 वाला.
Lord, I am praying mine should not be disposed of along with that because I am covered by the main judgment. I really need not. Otherwise, I'll again suffer, Lord, several years of litigation.
We'll consider.
Lord, last submission, those observations, my lord, in the order of contempt, not party that may not come in our way if you file a petition. That's all.
IA number, may I just quote the same?
IA number 19147 of 2022. Application stand disposed of. With an observation that it will be open for the applicants to approach the High Court for appropriate relief if they are claiming appointments on their individual rights, oblique merits, which may be considered in accordance with law and his own merits.
Same,
My
same
lord,
number, just
same
same order.
IN
Not the
number.
observations, my lord, the observations will not come in order.
We'll consider that. We are going to clarify that.
Same order can then happen in 193303 also. Because otherwise, I would say, Lord, I would really.
Correct. 193303 also. Same order.
And second December to be vacated.
We'll consider council.
Also, IN number.
That should happen, otherwise we can't go there.
Okay, we'll consider.
Same order, 196996.
196996.
6996.
Only
197091.
19
7091.
19.
Not in only one additional fact.
7091.
Okay, same order.
Not in only one additional fact. I was a civil appeal appellant here.
We'll clarify.
I'm not a writ petitioner there, but I was a civil appeal
Try
here.
to see. We will not see to it that anybody's rights are prejudiced.
That's right.
We consider it, council. On the contrary, we would not have passed that order of protecting the service
I
of
appreciate
others.
it. I'm only saying, Lord, if your Lordship sent us back to the High Court, please reconsider that also.
Most probably after clarification, you may not have to go for also.
It's against scheduled areas as well as non-scheduled areas. So there are a total of about 9,000 vacant seats. So I've just given a suggestion that how all the equities can be worked out. The persons who are writ petitioners first, they can be appointed against the vacant seats. Then the persons who are, the rest of them falling in the merit are concerned, they can be appointed against the rest of the vacant seats, your lordships. And one counselling can be done and the matter can be closed after that. That is all that I'm suggesting to your lordships. That's all.
That is for the state. We'll be hearing for 10 minutes tomorrow. We are over now.
But can I?
Only one thing is which is required to be considered. That those persons who were in the non-scheduled area, they were waiting for their appointments. Correct? The posts have remained vacant. But because of this dispute, suppose this writ petition would not have been there, correct? They wouldn't got the appointment. So what we are, please, we will consider, subject to hearing Mr. Sibal tomorrow, that those persons who applied in the non-scheduled areas, correct? They were already waiting for the appointments. But because of the pendence of the writ petition, further process was stayed. Correct? They may be also be appointed and their cases be considered in on merits, but without disturbing those who were already appointed. Suppose in a particular non-scheduled area, correct? Some person is having less mark, but he is not to be disturbed. Only thing we want to see that the appointments are made, and when 9,000 posts are vacant, correct? It will affect the education also.
I entirely agree with your lordships. I entirely agree with your lordships.
That is why, correct, those persons could not be appointed and the recruitment process could not be completed because of the pending litigation only.
The problem is, your lordships limitations the writ petitions, but there are people who are hired on merit and who can't be appointed because of the fact that the relief is limited to the writ petition. So therefore, it's important.
No, Mr. Council, we have restricted only for the purpose of non-scheduled and scheduled area.
So those in the scheduled areas who are hired on merit should be considered.
Correct. But those persons who were already applied for the non-scheduled area, correct? But the recruitment process was stalled because of the pendence of the writ petition, correct? So the High Court clarified that so far as the non-scheduled area is concerned, there is no stay. But for whatever reason, to be on safer side, the state government waited till that outcome. Now the outcome is there. So you continue with the appointment so far as the non-scheduled areas are concerned on merits.
Correct. We'll compute the numbers and come back to your lordships because we'll have to see the vacancies and the numbers. We'll
Okay,
come back to your lordships on that.
come tomorrow, we'll pass a year, 5 minutes and pass appropriate order.
Some vacations are from the scheduled areas. We'll come with the number tomorrow.
Okay.
That's right. Come with the numbers.
May I just put 10 lines, my lord, of your direction?
After fresh matters.
My lord, may I get 10 lines of your lordship direction at page 128 of the main judgment? Just allow me 10 lines.
Tomorrow you can.
My lord, as your lordship.
2 minutes बाकी है कि खबर.
That's right. As your lordship, please. No, I will come tomorrow, my lord.
Now we are in the mind.
I understand.
In our mind, the tomorrow's matters are.
No, I know, my lord. I don't want to trouble your lordship more.
Okay.
In fact, so tomorrow, my lord, the fresh matters. Because, my lord,
ये उसके साथ में अलग रखना है.
in so far as not saying that 212 should be also not tinkered with, therefore I need to bring to your lordship.
That is only with we clarify council.
Yes,
That those are with respect. Those are.
Sir, so far as we are concerned, therefore I want to show that 10 lines. I'll do it tomorrow, Milord, please. Sorry, Milord, for the interruption.
Rest of the matter section. वो second bit पे करते हैं.
Direction matter item 61 plus. The matter 61 is direction. Only for direction.
What is the direction?
So yeah, in the first list it was said on for directions. Because this is for today otherwise. Item 61.
Press matter.
No, Malad, it came in the regular list, Malad, earlier. The matter was adjourned and my lordship pleased to give a date of today, Malad. Therefore, it came as direction.
I appear in item 60. Oh, that is, I think.
Malad, Malad, it's a reserved price, Malad, auction matter.
It was listed for final hearing. My lord said that my lord will hear this matter on 14th. That's how this matter has now come up on the board.
Oh,
It was listed for final hearing.
वो any miscellaneous payment non NMD में कर दीजिए ना. Any NMD.
In January.
हाँ लाइए लाइए वो that.
Lordship,
There's item 55 also, there is a direction for NMD matter that can be listed.
That appropriate date will be. No mentioning, no mentioning, madam. नहीं ये नहीं.
60.
Press matter, press. Bar council. 62.
Office.
62. Yes, who is appearing for 62?
Just a second.
Rajasthan election.
Mr. Prasad will just. Really sorry, Milord, just.
So far as the other matters,
We'll give the date appropriately. Who is appearing?
Mr. Ardindu Moli Prasad appears for the Bar Council of India. It's just coming in, Milord. It's just.
We will not take up the matter.
Just
Tomorrow. List coming.
Well, this is a case because
We just kept tomorrow.
Lordship, please.
ये 22 वाला matter है. Except tax matters. वो post-it पे कर दो. January. बाकी appropriate date पे करो.